continue now with Part B of Section 1 of Student Rights and Responsibilities, having to do with a student that was accused of selling marijuana on a school campus. In this case, the high school junior had offered to sell marijuana to two students on school property. That's a key phrase. This was reported to the principal, who told the student of the allegations, gave the student the opportunity to respond, and when that occurred, the student denied those charges. After further investigation, the superintendent informed the student and parent he was going to expel the student for the rest of the semester, and the student and parent were informed by letter of the right to appeal. When the student went to the board to appeal the suspension or expulsion, the student was represented by counsel, but the board was not. The attorney was allowed to address the board but not cross-examine any witnesses or know their names. The board then went into executive session and voted to uphold the expulsion. The question here is, did the board handle the appeal properly, or if not, what was wrong? Well, the findings in this case are interesting. It was found that the school district had violated the 14th Amendment procedural due process rights, particularly in regard to cross-examining the student's accusers. The administrators who had participated in closed-door deliberations introduced new evidence in that closed-door session. Thus, the case was overturned. The next situation or case is called Bang Zero Tolerance. It comes from the Ethics of School Administration book that I often use. It is a dilemma between legal violation, moral and ethical judgments, and the best interests of the child. The question that you'll answer here is what is fair and just and meets the test of what's best for the entire school. This is a case of an elementary middle school student who had brought a gun to school to show some boys who were harassing him for his lunch. Every day that he came to school, they would confront him and ask him for his lunch money. Well, he brought a gun, which was discovered by a teacher. The question secondly comes is, did the school have to expel this child as a result of a zero tolerance policy? You might want to consider that as you think about what zero tolerance policies mean. The case to post or not to post on MySpace, kind of the forerunner of Facebook, occurred in February of 2006 here in Greencastle, Indiana, in a middle school. The principal had discovered a web page on MySpace purportedly he created. The student had not created the page or made derogatory postings on it, including one that noted that the principal could no longer control her, and that she would wear her piercings as she wished. Apparently she had numerous piercings. The school acted to file a delinquency petition alleging harassment, identity deception, and identity theft. The juvenile court, looking at the case, dropped most of the charges but found her to be delinquent and placed her on 9 months probation. The judge ruled that the comments that she made were obscene. The family appealed. The Indiana Supreme Court in 2008 of May overruled the judge who had placed the middle school student on probation for posting an expletive-laden entry on MySpace criticizing her principal. So the question then is, why did the judge uphold the student and not the principal or juvenile court? As you see in the next slide, the court noted that a key post appeared in a private section of MySpace that was not intended to be viewed by the public, but only by friends who had been invited by the user. The principal was able to use it and view it only after gaining access from another student who had created the site. Therefore, the student had no expectation that the principal would even see her post. A second post appeared in a more public area, but the court ruled that the content indicated that it was intended as a legitimate communication and therefore could not be construed as harassment under the law. You'll take a look at cases in chapters 6, 8, 9, and 10 as you have read through Student Rights and Responsibilities. The Bethel case, one of the better known cases, Bethel School District number 403 versus Frazier, which you should find on page 369, talked about the school discipline code, which prohibits the use of obscene language. A student presented a speech in front of a large group of students who were 14 years of age, using graphic and explicit sexual metaphors to nominate a fellow student for student elective office. The assistant principal indicated a violation of the school code to the student based upon 5 letters that were submitted to him by teachers. The student was given the opportunity to explain his conduct and admitted having given the speech and using the sexual innuendos, and was suspended for 3 days. First, the parents appealed, and they went through the district's grievance procedures, who upheld the violation but then reduced the suspension to 2 days. The parent then took further action to the district court on the basis of the First Amendment right to free speech, and at this point the parent was seeking monetary damages and injunctive relief. Well, what do you think the district court did? Did they uphold it? Did they reverse the judgment of the school, or dismiss the case? The case then went to the Court of Appeals. Did this court uphold or reverse the district court? The case then went on to the U.S. Supreme Court. Did this court uphold or reverse the decision, and on what basis? You can find the Bethel case in our case law book, and you'll be able to discover the conclusions to the case. The next case is a students in the internet case, something that is becoming more and more viable in schools today. And it's called Killian versus the Franklin Regional School District. This is a district in Pennsylvania. The case involved a student who composed abusive remarks about a teacher, which the student emailed to a list of friends from his home computer. That's the key words, home computer. The school suspended the student. What key factors would the court use to determine if a violation of First Amendment rights had occurred? The court found that the content of the email was not so offensive, derogatory, and threatening as to lead school officials to reasonably forecast materials and substantial disruption. The student could be punished even though the materials were composed at home and the website emanated from an off-campus location. We'll continue in the next few minutes to discuss student rights and responsibilities in Part 2 of the presentation.